Welcome to the weekend. Please kindly support this channel by hitting on the subscribe button. Do not forget to like, comment, and share. Thank you all. During a crucial hearing for his lawsuit involving sensitive papers, the former President Donald Trump was seen communicating with his lawyer. Todd Blanche and Christopher Kise, Trump's attorneys, were seen talking in each other's ears at the Florida hearing on Thursday. As the session progressed, Trump, seated between the two lawyers, paid careful attention to the arguments and made occasional remarks to Kise or Blanche. In several points throughout the hearing, Trump and his defense attorney Todd Blanche had intense conversations. NBC News' Catherine Doyle provided a description of the proceedings in the courtroom. He would sometimes lean forward and cross his arms in front of the judge. Trump sometimes pressed his back up against the seat. Trump appointee District Judge Aileen Cannon is deliberating requests to dismiss the charges in the Mar-a-Lago case. The former president contends that the Presidential Records Act, PRA, permitted him to take secret records with him when he left the White House, and his team is arguing that this is why the lawsuit should be dismissed. Cannon has been advised by the Justice Department, however, to disregard Trump's assertions. Due to his alleged mismanagement of the records, Trump is facing 40 criminal accusations, including deliberate retention of material important to national security and conspiracy to obstruct justice. He has denied any wrongdoing and entered a not guilty plea to all of the allegations. Prior to the lunch break, special counsel Jack Smith, who was present at the hearing and sent a few looks in Trump's way on Thursday, was allegedly given the cold shoulder by the president. In a pre-recorded interview with Newsmax that aired the night before the hearing, the former president had called Smith deranged and out to murder. During a segment of the hearing, while Cannon and prosecutor Jay Bratt were debating the retention charge, Trump could be heard repeatedly whispering into Blanche's ear. According to reports, Blanche laughed or grinned in response. The regulation is not just unconstitutionally vague, according to Trump's lawyers, making it impossible for him to know whether he was breaking any laws. Additionally, they contend that the disputed papers were Trump's private correspondence. That way, he could keep them with him when he left the White House. Presidents since George Washington have taken materials out of the White House at their own discretion, Blanche said the court during the hearing. Blanche was told by Cannon, who seemed dubious, "It's difficult to see how this gets you to the dismissal of an indictment." Those assertions, she said, would essentially gut the PRA altogether. When it comes to a trial defense, your arguments can still be persuasive, she said. May 20 is when the trial is supposed to commence, but Cannon is probably going to push that date out. Attorney David Harbach opened the prosecution's reply by stating, "The materials mentioned in the indictment are not personal records." Clearly, they are far from that at all. Once again, the legal team of former President Donald Trump achieved a significant win on Friday when the chief prosecutor or the district attorney were compelled to withdraw from their Georgia election lawsuit. The lawsuit might be delayed by weeks or perhaps months due to the judgment. To the charge of unlawfully influencing the outcome of Georgia's presidential election, Trump entered a not guilty plea. According to the presumed Republican presidential contender, the lawsuit has political motivations. Judge Scott McAfee harshly chastised Fulton County District Attorney Fani Willis on Friday for her tremendous lapse in judgment in her connection with prosecutor Nathan Wade, as well as her lack of professionalism in providing evidence in the case. He said he was unable to remove them both, however. He ruled that the defendant's assertions of an actual conflict of interest must be rejected in the absence of adequate evidence that the district attorney became personally involved in the prosecution or that her financial arrangements had any effect on the case. This decision does not, by any means, imply that the court accepts this grave error in judgment or the district attorney's evidence at the evidentiary hearing, which was conducted in an unprofessional way. Willis has already said that the trial may go until January 20, 2025, the day of the president's inauguration. It is quite likely that the case would be delayed beyond inauguration if it were to be moved to a different prosecutor. If Trump is elected president, he may then request that the lawsuit be postponed until after he leaves office by the U.S. Supreme Court. New York University law professor Stephen Gillers told Newsweek that